Is Advanced U.S. Immigration with Anindita Chowdhury from USI Law. She's Washington, D.C. based, and a good friend of mine, someone I enjoy working with quite a bit. Oh. Can you put it back to her presentation? Ooh. Excellent. So during Anindita's presentation, she'll be covering the following topics. I'm sure you'll find them all very, very relevant. One is trends in requests for evidence, some things that we've talked about a little bit this morning already, but she's going to build upon that and bring it up to another level. She'll talk about the matter of Simeo solutions, labor condition applications and the roving H-1B employees, complexity in the PERM process for green cards, challenging L1 filing, A and B subject matter that will be helpful, on-site inspections, H-1B and PERM audits that you might expect, what to do in those cases, and then the new and developing option for entrepreneurs for a parole from USCIS. So these will be wonderful topics, and we're looking forward to hearing from Anindita on these subjects. Anindita is a founder of the USI Law firm, as I mentioned. She has 23 years of experience in immigration. She has her law degree from Washington College of Law, has a master's in government, and a bachelor's degree from University in Calcutta. So she's also local and understands many of the issues, of course, that you face. She's become a speaker and invited to many such conferences as this in the United States and elsewhere. She has great connections with U.S. government on Capitol Hill there and is involved with regulations and helping to form the policies at the various meetings that where stakeholders are invited. She has many range of clients coming from the corporate sector, all industries, from Fortune companies all the way to the smaller startups and other types of entities. She also has been involved recently in the EB-5 investment for green card program and is advising many of the wealthy investors to come and how to obtain their green cards in the U.S. through that process. And so with that, Anindita, I'd like to turn it over to you, and thanks for being here.
Thanks, Jay. Thank you very much. Welcome, everybody. Thank you so much for being a part of this conference. I know there are some very regular and familiar faces that I see around the room. I hope in the next 2 days you will learn and be educated about the challenges both with US immigration law and also global immigration. I know the INSZoom team puts a lot of effort to build a coalition of qualified speakers, both from the industry and also the legal industry and the IT industry, and hopefully this will be very helpful to you guys. Jake has introduced me and my firm, but I just want to share just one more slide, which at USI Law, we have a few key differentiators. We believe in solutions, service, and success. As far as solutions, our solutions are highly customizable, scalable, and integrated systems with proven success and methodology. Over the course of this presentation, I will make an effort to go into specific examples that how we handle cases, which will cover some of the questions that came up both in Jake's presentation, at the end of Jake's presentation, and also some that came up with the global visa presentation. Seems like we had a lot of US visas-based questions, but I will definitely make an effort to address all, if not most, of what I can given the time frame. Service, we are always responsive and accountable. Customer service is what we pride ourselves, and I'm equally proud to tell you a particular client of ours, a CFO of a multinational appliance manufacturer, one of the leading appliance manufacturer companies, quoted me and our services to be that of a pit bull. We are a pit bull for our clients, and that I take to be a large compliment. Success, I'm very proud to represent our firm and tell you that we have almost 100% success in all visa categories. I know this is a little unbelievable given that today's age and direction with US immigration, but I'm not exaggerating. We have as our client one of India's largest IT companies. They use multiple law firms, and I will tell you that with their EB1C projects that we have a 100% approval rating and a 2% RFE rating. You know that is almost unheard of. I know everybody is very anxious and nervous, to say the least, of what has transpired in the last 24 hours in the US, and having selected that to be my second home, I do want to allay your fears and reassure your concerns. It is my opinion that, as far as I'm concerned, the US, if it wants to maintain its position as a superpower, will always have to open its doors to business immigration. It does not make a difference who the candidate is. I know Donald Trump, and all of you have heard the very erratic and irresponsible comments he's made. At the end of the day, I don't think he will be able to implement most of what he's threatened, at least when it comes to business immigration. For the 11, or in my opinion, 15 million illegals, time will tell what he can do with it, because I don't want to digress, because I have my personal opinion about those individuals who actually helped the US economy greatly. But either way, time will tell. But as far as US immigration, which is what touches all of us in this room today, I can reassure you very confidently, even Donald Trump, much before he got into this election hoopla and this mentality of just speaking his mouth when he, and expressing what he thinks, he was somebody back in the 2012 or 2011 days, he was one of the believers who propagated increasing the H-1B. Now, time will tell whether he'll stick to the same story, but I can guarantee you he cannot eliminate the H-1B visa. As I've had this opportunity during this recent trip to India, discuss with several of my clients, several of professionals, the H-1B, in my opinion, is a stealth weapon of the US. It gives or empowers the US to provide for several millions of educated professionals to help what is their infrastructure. So I really don't see that being affected. There will be immigration reform, and time will tell how that will shape up. But I can assure you, the US immigration, as in corporate immigration, business immigration as we know it, should not be touched to a large extent. And overall, Republicans are more immigration friendly, just by trend. So, but time will tell. I mean, Donald Trump also, as we all know, is not a typical Republican. But I don't think we have to be worried too much about negativity towards what we do for a living. That's my 2 cents. Time will tell. I can come back here next year and we can compare notes of what has happened since then. One big thing that will hit all of us, effective December 23rd, we will have an increase in USCIS fees. So you can get this on the government's website, but we've just captured a few. The I-129 has gone up from $325 to $460. The I-131 has probably had the highest percentage of increase, which is a travel document that you include when you do the adjustment of status for your employees. That has gone up from $360 to $575. And here is a listing. You can literally Google and go to the USCIS website. Or I think you will have access to all our presentations at the end of the conference, so you can look this up. But it is anywhere between, for the most part, a 7 to 8% increase to a 60% increase, which is quite alarming when it comes to certain categories, but it is what it is. Recent trends, which is one of the things that we are discussing today, clearly we can sense that across the board, no matter what the type of company is, what the type of business is, there has been an increase in RFEs. Specifically in the HCAP season, we see that. And the trends of that, I want to spend a few minutes discussing that. They're going after petitions where they need documentation of what we consider to be in-house employment. What do I mean by that? They need proof that this petition that you have applied for your employee, that you have documented proof of specialty occupation. Basically, if you're requesting for a 3-year visa for this particular employee, you will then have to back it up with documentation that will show this is how we are going to employ this candidate for the length of the 3-year visa. This is the nature of our business. This is the nature of the clientele we have. This is how we service our clients. Now, you can argue and say, you know what, most of the MSAs, Anindita, if you know, don't last more than a year. I mean, not MSAs, sorry, SOWs. MSAs last multi-years. So you will have to come up with a legitimate legal argument where you have to document the relationship that you have as the petitioner with this a particular client where you're going to actually place this candidate, if it is a situation like that, and then justify that there is no misrepresentation here, that you do need this candidate for the length of 3 years. There are different ways to document it. There are different ways to write it up in a support letter. I will share something that we do at USI Law, which I respectfully disagree a little bit from what was discussed before, of how much should you put in. And I will tell you from personal experience, because we do this for our clients that give us thousands of cases and a startup client that give us 2 cases. And our commitment to our clients are, we prepare documents, at least from our best interest. Everything that an RFE will ask you for is already included in the support letter. That takes a lot of work. Our support letters go on for at least 9 or 11 pages. And I'm telling you, just from experience alone, they read it, they see it, they value it. We have an extremely high percentage of 3-year approvals, and we have 0 denials. And it's a lot of work for the lawyers, especially if it is a law firm that you're associated with, or a lot of work with your in-house team, if you have an in-house team, to put in that in the get-go. I'm not saying if you have everything in there, you will get 0 RFEs. No, please don't think that I'm stating that. There will be a significant decrease because you're doing their work for them. In an event where we have seen maybe 10% of the cases, we've already provided everything, but they still standardize, generate that standard 4 pages, 5 pages RFE. Doesn't make a difference. You can always rehash it and reconfirm. But we have seen putting a lot of these details in the beginning of your petition really helps the petitioner. I personally feel it's a disservice that if a law firm does not do that, towards the petitioner, but that's my personal opinion, that's the way at least we operate at USI Law. In-house employment, to go back to the slide, office space, they're starting to ask for, mid to small sized companies. They want photographs of the office space, proof of valid contracts. We've talked about that. Now, the placement at client sites, which is where the Neufeld memo began. We all know, and I want to be very blunt about it, the dirty word is body shopping. We are all Indians for the most part in this room. We know how that works. There was a significant percentage of fraud, if you want to call a spade a spade. And that is what they clamped down on, like they should. Any right-minded professional sitting in this room will say there was a misuse of the law. And it was a great thing that they clamped down. But based on that, now you have to document what we consider to be his right to control, employee-employer relationship. So when company ABC is placing Mr. Srinivas Reddy, hypothetically, at that client site, what control does company ABC have over this professional? We know quite a few times, especially in smaller companies, you just ship the person off to the end client side. The end client manager supervises him or her. The end client manager is who they're accountable to. But that's against the law because you are the petitioner. You are the person who has to document, this is our employee. And there are ways to document how you will tie into the documentation, the paperwork that you submit. This is what we do to review him. This is how we check up on him or her on a weekly basis. This is the feedback we get as employers, et cetera, et cetera. And I would request you or appeal to you that document should be non-fraudulent. So that's right to control. Another big thing is specialty occupation. The definition of an H-1B visa, I'm sure all of you know this, is a specialty occupation. What is a specialty occupation? It's basically a profession that requires a minimum of a bachelor's degree. In addition to that, the candidate that you're selecting for this position must have the similar specialty, such as, if it is an IT position, so typically what we look at is a computer science educational background, engineering, math, science, the IEEE that came up, the electronics and electrical engineering, that kind of background. You can't have somebody in geography or history doing the IT position. Now, alternatively, you can argue with me and say, hey, this candidate might have started in a bachelor's in geography or BA in India, but he's got 25 years of IT experience. You will have to then, in that situation, build the argument how this person is qualified for this systems analyst, program analyst, computer program, software engineer position. So depending on who you select, most of you guys do have an alignment to people who have the engineering, computer science, math, engineering field, so it should be more straightforward. Educational credentials, as you all should know or must know, that if you have a degree from a foreign university, so if they're from an Indian university, then you need to do a credential evaluation, which will then document that the degree that they've gotten abroad is equivalent to the degree that you're expected. That's the minimum for bachelor's per US standards. Specifically for in-house employments, I want to talk about the H-1B RFEs that we sometimes handle. How do you document such when they raise the issue of specialty occupation? How do you resolve the in-house employment aspect of it? There are two parts, right? As most of you know, there is the angle of the end client. We're going to get into what documentation we need for that. And then if you don't have an end client and you actually have like a large office with a development center or something like that, you will have the in-house products. So how do you document in-house what work is to be done in-house? So there you provide the end client contracts if they're sitting in-house and working on them. Then if you have products, that's the only way you can choose this aspect of it, or the most significant way. So you need to then document, you need to have patented products. You have to have white papers for that. Then you have reviews from established companies like Gartner and others who are talking about your product. There are many Indian IT companies that have fabulous products. And you need to sell yourself. You need to document why this particular product is the hottest thing in the market. And this is how it helps not just the Indian market, and this is how it's helping our clients in the US. So there's a direct correlation between the product and what it does. Then, in addition, there are marketing materials, there are newspaper articles, et cetera, and what we've found to be very helpful is an itinerary of services, which is a minimum requirement. I don't care what anybody tells you otherwise, an itinerary of services, which is basically when I train my staff, when I talk to my clients, I always say, always remember who your audience is. That is who you're working for. Today, the audience is not me, it's not Umesh, it's not Jake, it's not your supervisor. Who is it? Can somebody say real quick who the audience is? The immigration officer. It is our job when we prepare a petition, whether with a law firm or in-house with your legal team, to prepare a petition that makes it easy, cookie cutter, spoon feeding, whichever word you want to use, for the immigration officer to judge and assess a couple of things. That you've met all the requirements for an H-1B visa, the specialty occupation, the prevailing wage, the LCA for the location, et cetera, and you're a non-fraudulent company, because there is, as we know, a lot of fraud. So combination of both, think of yourselves being that immigration officer. And if you assess the documentation and you would deny the petition, don't submit it. Work on it to beef it up even further. Or work with your attorney and make them document it even further. Okay? This is how I will tell you, you will see results. Do not wait for an RFE. An RFE is something that will just add to your misery. It'll add to your cost and add to the work, both of your attorney and yourself. You can do your homework before you send the petition in. We've done it, and we've had amazing success. Okay, client placements. We talked a little bit about this. Right to control. Right to control, we have to demonstrate the ways and means in which the company proves right to control over its employees. So here you have, to go back to Mr. Srinivas Reddy, who is an employee of ABC, you basically place him in, Des Moines, Iowa, okay? What control, and you're based out of Princeton, New Jersey, what control do you have across the country? So here's this somebody in Calcutta placing somebody in Bombay. So what control do you have over that employee? So how do you document that? Internally, what is your procedure? Each company is different. There are some commonalities, obviously, but HR processes, how do you control what this person does at the end client? So that is documentation that you need to line up and keep and then share with the USCIS. Understand the underlying regulation governing our right to control. I explained to you how that works. Specialty occupation, how the position meets regulatory requirements. We've talked about the position, so we said the candidate you select must have a related degree and related experience. So depending on what the position requires, the candidate must match up both education and professional experience. Provide a clear understanding of the beneficiaries' education and work experience related to the position and the nature of the work. So there has to be a marrying of both. You will never select somebody who's not qualified for the position. It's just that you have to document it in your letter. You have it in your head. Your tag team, your HR team, your recruitment team has done it. But then you have to transfer that into your petition. Why this is the best candidate for our company. Why our company deserves this visa for this particular professional. Moving on, educational credentials. I told you it's super important that it must be evaluated by a credible credential evaluation company and document that this person has the minimum requirement of a bachelor's degree, which is the requirement of a specialty occupation.